The case is now being recorded.
We continue our session this morning with an impounded matter. This is a case involving the termination of parental rights, case number 2022 P975, the Department of Children and Families and Others versus the mother and the woman. Attorney Penta, you may begin.
Thank you, Your Honor. May it please the court. My name is Attorney Michael Penta, and I represent the appellant mother. I'd first like to start by recognizing the realities of this case, that there are 3 children, one with significant special needs, all fortunately placed in the same pre-adoptive home. There's no easy feat. And that my client did have struggles with substance abuse, was inconsistent with services as well as visits, and was unconvincing to the court or to the department that she had completely separated from the father. But the judge also relied on other factors such as domestic violence, inadequate housing, and the effects of mental health on her parenting that had little to no evidentiary support. And at a minimum, this court requires a remand for the judge, the trial judge who is entrusted with the decision whether to make the permanent severance between a parent and a child, to decide whether, when those factors are removed from her analysis, or his analysis, excuse me, whether there is still clear and convincing evidence of parental unfitness, and whether termination of parental rights is an adequate remedy in this case. With respect to domestic violence, there are 2 issues here. There is one.
To begin on those specifics, your opening description of your argument implicitly corroborates my belief about the nature of your argument. You do not, in your brief, challenge the findings concerning substance abuse or failure to engage in services.
Well, Your Honor, I do recognize the discretion that this court and the standard of review this court applies to those findings, and I can't with confidence convince this court that there isn't evidence in the record that those matters exist. Whether I believe it or not is a different story, but we're not here to judge what I believe. It's really what the court. I'm sorry, Your Honor. If I may, there's a delay, so I see your lips moving, but I can't hear. So I apologize if I feel like I'm talking over you. It's not my intention.
You understand that? Just to be clear, you are, for purposes of this appeal, as a matter of challenging the integrity of the decree, you are not challenging the findings of unresolved substance abuse or failure to engage in services.
I did it in my brief, and I don't intend to in this argument.
And setting aside for a moment the issue of domestic violence, it seems to me, at least, and as you're aware, the department argues that substance abuse is in fact at the center of the challenges on both housing instability and mental health.
Yes, I'm aware that, and well, with respect to the housing instability, at the time of trial, my client had established that she was living with a woman who was somebody who was prominent in not only her life, but the children's life. I believe she was either a daycare provider, and so somebody who was familiar with the family, somebody who had adequate, at least, rooms and the nature of such to provide.
This testimony on that arrangement was inconsistent and consistent with a conclusion that it was unstable.
I disagree that I agree that it was not clear, but I disagree that it was inconsistent in the sense that she did establish that the parent, or excuse me, the homeowner, the caretaker, who she considered like a mother to her and the grandmother to the children, really didn't place a time limit on exactly how long she could stay there. They probably have had a discussion just to set somewhat parameters. And I think initially it was 60 or 90 days, I believe, to her to get accustomed to having the children in the home before she would expect her to do other things. Like, I mean, I think that would be the expectation, is that she would get a job and she would be self-sufficient, but I don't believe there was an actual like lease, for example, or temporal limit.
Can we agree it was confusing in that it was not permanent?
It wasn't intended to be a permanent situation. I think it was a transitional situation, but I mean, we can all agree that the case law is that homelessness is not a basis for terminating at least a parent's rights. And in this case, the mother, I think that was an issue that the judge may have made an issue that probably was a non-issue.
Mother also, because of her substance abuse, required treatment in a residential treatment facility and had failed to adhere to the program requirements for the facilities where she previously had been housed, which adds another variety, another type of instability in her housing.
Yeah, so I think you touched on it, Your Honor, from the beginning. The crux of my argument is not that the substance abuse was an erroneous finding, but the judge did layer that her decision is couched in at least 3 areas where the evidence has little to no evidentiary support, such as domestic violence, I submit housing instability, or at least adequate housing, and her mental health. And to the degree that a termination of parental rights is permanent, irrevocable, that the trial judge's decision, the trial judge's decision, of course, should be reconsidered without those factors in place. But also, it's important because unlike, I don't practice criminal law, but unlike criminal law, where I'm sure this court's looking at specifically that particular crime, regardless of a criminal defendant's past history, these cases all involve past history. So if there's domestic violence in the department's records that doesn't comport with the evidence, then of course in the future this parent's going to have to contend with those accusations in the future. And so it does have ramifications. I think we don't even have to look beyond this case, is that my client does have a 4th child with a different man who was, in her description, an actual domestically violent relationship. And so, it does want to remind the court too that the department in this case didn't make an issue of domestic violence. It didn't add it to an action plan. It didn't require mother to engage in any services for domestic violence. So, there is an action plan. It's written. It has tasks. There should not be acceptable tasks outside of that plan that a parent is expected to engage in now or in the future.
In the final decree, did the judge rely on domestic violence, or was that just one of the things that he considered in the totality of the circumstances?
So the judge did, I would say it's one of many factors. It wasn't the only factor, but the judge himself had relayed that it was one of a major factor. And to the extent that it is a major factor, if this court is inclined to agree that there is no or little substantial evidence of domestic violence in this case, or that the department did anything to assist the parent in addressing that.
But wait a minute.
And the little substantial evidence, did that come from the mother herself?
Well, if I actually look back at the testimony, and part of her disclosure was part of the intake process with the counselor at the Hart House. So they ask questions. I mean, it might be similar to saying, when you go to a doctor's visit, they ask you questions and you want to be honest. You want to say, this is what happened in my relationship. We yelled at each other, kind of get an adequate, baseline as to what your situation is. But we don't have any substantial facts, what specifically happened, when it happened, if it even happened when the children, this is a 14-year relationship. So part of their relationship was before the children were even born. So the parents did deny physical. I think that's pretty obvious what constitutes physical violence in a relationship. But emotional and verbal could be subjective, depending on the person. And to get a baseline of that, I mean, I would say there's an objective nature to it, of course, but someone to inquire as to whether or not they're in a verbally or emotionally domestic violent relationship.
Ask you a question. But the social worker testified, she reported that she was ending the relationship, and she reported that they had a history of domestic violence, including physical, verbal, and emotional abuse. Isn't that evidence of domestic violence?
I think the parents were pretty clear from the beginning that there was no physical domestic violence. I can't, what was, what my client may have said to the social worker and what was interpreted from the social worker. But if that was the case, then the department should have done more in terms of services. If they're considering that there's domestic violence in this relationship, then there was inquiry that should have gone. I mean, there was.
The mother said that she was ending the relationship and clearly did not. I mean, I think that is something of a red flag in this case, isn't it?
It wasn't because of domestic violence, and she admittedly, I mean, she testified that the father is a toxic person in her life. But again, I mean, to the extent that the judge himself cited as a big portion of his decision that domestic violence in housing were predominant factors, one of several, but predominant factors in the decision, then if those are, those are part of it, then it should be for the judge on remand to determine whether the remaining findings are sufficient to terminate parental rights.
Let me go back to something that you mentioned during your introduction to the case. The children are placed in a single foster placement, pre-adoptive placement, which these cases is something of a win. The disposition that you are suggesting would delay the progress toward permanency. And one of the things that we need to assess is the likelihood, seems to me, that that stripped of, first of all, we need to consider whether you are correct in that the basis for relying on domestic violence, unstable housing, and mental health was not adequately supported by the record. But if any one of them is overemphasized in the judge's findings compared to what the record supports, we need also to evaluate the likelihood that the judge would reach a different consideration on a remand, which would further delay permanency in these children's lives. Do you care to comment on that?
No, I understand the position this court is in, and I understand, the job that I have to do. But the reality is that, these cases sometimes resonate beyond what this court decides. There are findings that are made in the lower court that have repercussions and implications to a parent down the road. If this court is inclined to affirm based on, I guess, would be harmless error, then at least implore this court to acknowledge that the trial court's findings were a step too far. In fact, that there were recognitions of parental deficiencies that just simply didn't have evidentiary support or didn't deserve the weight the judge applied to them in this case. With that, if there's any further questions, I would submit and rest on my brief because the remainder of my argument is consistent with probably what's articulated in my brief.
It's fair to say that the judge concluded that there's no question that mother loves the children and that the children love mother, correct?
Oh, yes. I mean, I don't think there's any lack of love. Or, there was, in fact, a recognition of that by awarding visitation with the children. So, I understand that my client is, in the judge's findings, have most of them have evidentiary support. Some of them don't, and to the extent that they factored in the ultimate decision, deserve correction. And as a court of correction, I implore this court to fairly at least consider those aspects of the arguments that I've raised both today and in my brief in its decision. With that, I will rest on my remaining time and rest on my brief.
Thank you, Attorney Post. For the department, Attorney Kernan.
Thank you, Your Honor. May it please the court, Jennifer Kernan for the Department of Children and Families. This court should affirm the decree terminating mother's parental rights because the court properly determined that mother, who had failed to address her own significant needs and struggles, was unfit to parent the children, the oldest of whom had been removed from her care 4 times, and was correct in determining that termination of mother's parental rights was in the children's best interest.
Was domestic violence an issue?
Yes, and I think it was an issue. The question is the degree.
Was it an issue sufficient that it should have been in one of her action plans or one of her tasks?
Not necessarily, Your Honor. And I will note that the department did include in the family assessments, the department did include or consider that mother's ability to manage the impact of domestic violence on her family was something that mother needed to work on.
Well, how was she going to work on it if she wasn't tasked with a task to work on and improve?
Yes, I understand that point. And I think what there was included in the action plan is individual counseling and therapy. And that would have served as a place for mother to sort of address that, to come to understand that.
Well,
and
the need for therapy had multiple independent sources. In the absence of a specific reference to domestic violence in the services or action plan, how's the mother supposed to know that that's the issue?
I think partly through conversations with the social worker. This court did note just a moment ago that there was a conversation early on with the social worker where mother admitted to domestic violence being a factor in her relationship. Mother.
That goes to the presence of domestic violence, but not to its significance as an issue bearing on or influencing the termination of her parental rights.
I understand Your Honor's point, and I think here at the very least, there is evidence that mother's relationship with father was unhealthy, and that's at a minimum. And mother's conversation with the Heart House clinician, which Attorney Penta referenced earlier, it may have been an intake conversation, but during that conversation, mother admitted that she was asking the Heart House counselor questions about what constituted domestic violence. And in that conversation, she came to the conclusion on her own that her relationship was indeed, or did indeed consist of domestic violence, specifically emotional and verbal abuse. She admitted that father was emotionally and verbally abusive to her, and that she in turn was emotionally and verbally abusive to him. So while it's true, yes, the department did not specify that mother needed to seek counseling for the purposes of addressing domestic violence. The fact is that the department did indeed require or put on her action plan an individual therapy and counseling task, which mother failed to do.
That's true, but that's not domestic violence specific. Didn't one of the children comment or testify that they observed or daddy hitting mom or something like that? Wasn't there some?
I don't recall that in this case, Your Honor. I don't believe that the children testified here, so I can't specifically confirm that. But the children have been removed multiple times. As I mentioned, the oldest child was removed 4 times. She was 10 at the time of trial. And in addition to the considerations regarding mother and father's unhealthy relationship, the court considered that mother had failed to address her longstanding substance abuse, including fentanyl use, and that impacted her parenting. In March 2021, just a few months before the trial began, mother tested positive for fentanyl and buprenorphine, and that's finding of fact 182. By mother's own testimony, she was not engaged in any substance abuse treatment at the time of trial. And historically, looking back over the department's involvement with the family, mother was unable to complete the required residential treatment programs. And these were the department was recommending residential treatment programs because the outpatient programs that mother had attempted were not sufficient to address her level of need regarding substance abuse. She was terminated from Heart House in January 2021, about 5 months before trial, following an altercation with another resident at that program, during which mother spit on that other resident. She was offered substitute placement, and that placement was not where she could have reunified with the youngest child, but she refused that placement. And when she did engage again in outpatient therapy at AdCare, She was advised to attend recovery support groups as well as individual counseling, but she didn't appear for the counseling or the groups. She was ultimately discharged from AdCare for missing too many appointments mere months before the trial. And additionally, these are children who have significant needs. As I mentioned, the oldest child, who was 10 at the time of trial, had been removed from mother's care 4 times. And she has IEP services to address communication, behavior, and social emotional development. And according to her IEP, she had developmental delays as well as an emotional and communication disability. Those are severe or significant behavioral needs, and mother who was unable to address her own needs not be in a position to address this child's need. The oldest child additionally had struggled with bedwetting and accidents at school since 2017. She's been diagnosed with trauma as well as ADHD. Her behaviors required a weekly behavioral chart to address her screaming, running, and wandering, as well as her bathroom accidents. And the behavioral chart did work to some extent. However, there are still days when the oldest child is off task, at least as of trial, there were still days where the oldest child was off task, screaming, or wetting herself. In addition, the oldest child has sees an in-home therapist weekly, meets with an individual therapeutic mentor weekly, and sees her counselor at school twice a week. There are a number of supportive services that this child requires. And given mother's history with her inability to sort of adhere to services, it seems unlikely that mother would be able to provide the support and care for particularly the older child, but the younger children as well. The middle child.
I'm sorry, Attorney Penta seems to focus not on her failing to comply with services, but on domestic violence, housing instability, and perhaps mental health. And so we've talked a little bit about domestic violence, and I believe it was the youngest daughter who had reported to one of the investigators that daddy hit mommy, daddy yells at mommy, daddy sometimes mommy hits too, or something of that effect. But leaving that aside for a moment, can you talk about housing instability?
Sure. Particularly, mother testified at trial that she was living with Ms. M, I believe it was. But as this court just acknowledged, the testimony was confusing as to sort of the exact nature and duration of that. And given mother's history in terms of housing, particularly that she had been unable to comply with the rules of residential treatment programs necessary to address her substance abuse, she was unable in that period of time to sort of to maintain stable housing. She was terminated from 2 residential treatment programs. She was subsequently living at a sober living. She left there. And then with Ms. M, where she was staying at the time of trial, mother's own testimony was conflicting as to how long she'd be able to stay there. And that mother's sort of confusing testimony was sufficient for the court to determine that this might not be the appropriate, safe, stable, secure housing that the children require.
Was the department aware that mom was staying there prior to trial?
No, mother had been not forthcoming in terms of where she was staying. There were periods of time where mother was out of contact with the department. And I think when the department did make contact, or when mother contacted the department, I believe it was February 2021, to report that she had been at the Willing House, but had left that. Mother would only tell the department that she was staying with a friend. She actually stated that it was not Ms. M, but it wasn't until trial that the department learned that she was indeed staying with Ms. M. So at the point of trial, before the department had learned where she was staying, the department had no idea what her housing situation was like, and was therefore not in a position to sort of properly assess what that would be like and what that would mean for the children. And I think here, this is a case where totality of circumstances matters. The substance abuse and her lack of ability to address that is a huge factor, and it's all intertwined, as this court mentioned. her inability to maintain stable housing, her inability to address her substance abuse and disengage, putting aside the issue of domestic violence, but her inability to disengage from father, with whom she had acknowledged her relationship was unhealthy. It's a constellation of factors that support the court's ultimate determination that mother was unfit to parent these 3 children who had been out of the home for at least 2 years, I believe, at the time of the trial. And the youngest child hadn't spent more than 3 weeks in mother's care after her birth. If there are no further questions, I will rest on my brief and ask that this court affirm the decision below.
Seeing no further questions, thank you. Thank you for your argument. We'll hear from Attorney Medeiros for the children. The child number 3.
Good morning, Your Honors. Linda Medeiros on behalf of the 3 children. I would like to address the questions of Judge Green and Judge Desmond a little bit regarding the domestic violence and the extent to which the judge may have relied or potentially overly relied on that factor, and point out, as I did in my argument, that there are 5 at most findings on domestic violence relative to 271, I believe, total findings. And if you look at conclusion 29, the trial judge makes clear that his termination of unfitness is based on mother's long-term substance use, inability to resolve that issue, and her untreated mental illness. Nowhere in conclusion 29 does the judge mention housing instability or domestic violence as significant factors. And I would argue on the children's behalf that this case is really about mother's long-term substance use problem and drug addiction that dates back to her teenage years. My oldest client, who is 13 now, this mother has been involved with protective services since she was 6 months old. So we have a mother who has twice successfully been reunited with her oldest child by entering inpatient rehab drug treatment programs, and succeeded in getting the oldest child back twice. And then in 2018 and 2019, the 2 older children were successfully reunited with mother after mother complied. The services asked of her to achieve reunification. So this is a mother who knows what she needs to do, and she's done it. But this time, on the 4th removal of the oldest child, and the 2nd for the middle child, and the 1st for her new infant, she simply was unable to do it. And that's the reality that my clients live with, because they do love their mother. Certainly the oldest 2 had an opportunity to have time with their mother when she was drug-free and stable and able to be a good parent. But she's not able to sustain it. And that's really what this case is all about. As the trial judge correctly found, enough is enough. At some point, the children deserve better. They deserve a chance to move on. And they are, as Justice Green noted, lucky. You know, this is a win they have together. The 3 siblings in a home where their needs are being met. And I see my time has expired. So on behalf of the children, I'm asking that the court affirm the judgment.
Thank you all. That concludes the argument in this case. The case is submitted. We will take a very brief recess while we make our way to courtroom 4, the Hale courtroom, and we'll resume the remainder of our hearing list in person in a few minutes. Thank you.
Thank you.